Okay, well, we are overwhelmed by this crowd, and thank you so much. What great enthusiasm for the topic of abortion still. So welcome to the second Zaremski lecture of the spring semester. We are grateful to our donors, Miles and Elena Zaremski, whose generosity enables us to have these events. And we apologize for running out of lunches. That is, we just didn't expect this, but hopefully most people got one. So today we have a special treat, which is, I think, why we have this turnout. We have two of our very own extremely prominent professors, Professor Jessie Hill and Jonathan Adler. And their program is entitled The Next Big Abortion Rights Case. So we didn't want anything too provocative. So if you have an empty seat next to you, can you please raise your hand? Okay, folks, take the empty seats. If, you know what, if somebody could maybe from that top row move to accommodate, we're bringing more chairs, but we need to accommodate someone. Yeah. Okay, thank you. Anybody else with free chairs? All right, we have one more, yeah, okay. So before I introduce the speakers, we do have a couple of administrative matters. We will be taking questions at the end. They will try to stop around 12:40. If you are joining us remotely, please put your questions in the Q&A, not in the chat. We do have somebody monitoring Q&A. If you are seeking CLE credit, we will put that towards the end of the program in the chat, and I will also read that out. So I could spend the whole hour introducing our speakers because they are so accomplished, but I'm not going to do that. They are both longtime faculty members and extremely productive scholars. They are fixtures in the media, if you look at Case Daily, and they have each won many, many awards. Professor Adler is the founding director of our Coleman P. Burke Center for Environmental Law. He also teaches administrative law and constitutional law, which is what is relevant here today. Professor Hill is our Associate Dean for Research and Faculty Development, so I work closely with her. And in addition to teaching, she's extremely well known as an active litigator who has worked extremely hard and successfully to promote reproductive rights in Ohio. Professors Hill and Adler don't always share the same viewpoint, so it's always really fun to listen to them and extremely educational, so I'm really looking forward to this. Take it away.
Thank you so much. Wow, it's so nice to see everybody here. So I hope we won't disappoint. And I don't know if folks came for the free lunch or if they came hoping for fireworks, but we'll see what happens. I think we have some areas of agreement that maybe more than you might expect on this case. One of the reasons being that this case is not about the constitutional law of abortion rights in the way that, although it has a huge impact on abortion rights, the real key legal issues are kind of elsewhere. And that's what we're here to pick apart and to discuss with you today. I'm going to start off giving a kind of background, a very quick background, what you need to understand about the facts about the medication, mifepristone, that's at the center of this lawsuit. And then we're going to kind of go back and forth and discuss the background and the various issues. So abortions can be performed either medically with a medication or what's sometimes called surgically or procedurally is sometimes referred to. And what we're talking about here is the medication that is used in medically performed abortions. And particularly, there's actually two medications, but the first one is called mifepristone. That's its generic name. And it's taken it can be safely and effectively used to end a pregnancy, an established pregnancy, so not to be confused with like the so-called morning after pill, which is an actual contraceptive. This ends an existing pregnancy up to about 10 to 12 weeks of pregnancy. It can be used. And this is the first medication that is taken, and what it does is it stops a pregnancy from growing, and then 24 to 48 hours later, the person takes a second medication called mifepristone, which causes the body to basically expel the pregnancy, very similarly to what happens in a miscarriage. As of today, slightly over half of all abortions in the United States are performed in this way, medication abortions. The medication mifepristone was actually first approved in the US by the FDA in 2000. It was invented, and first approved in France actually under the name RU486 back in 1988. So it's been around for a very long time. It has been studied extensively. It is safer than Tylenol, and it has other indications in addition to abortion, including it's used in miscarriage care, and a different brand name of the medication is used for something called Cushing's syndrome as well. The medication was, when it was initially approved back in 2000, largely, it seems, because of politics, basically. It was approved under this special expedited process, and maybe you can, I don't know if you'll say more about it, but special expedited process that was used primarily for life-saving medications that allowed for expedited approval, but under particular restrictions that were placed on the medication. And so those restrictions were placed on the medication for a long time in terms of how it could be prescribed and who could prescribe it. And the restrictions were gradually loosened over time with big changes in 2016 and 2021 that made the medication more accessible and more available. And I think, should I say something about what those changes were, or do you want to talk about it? A little bit. Okay, so some of the key changes were in 2016, the labeling was changed to say that the medication could be used up to 10 weeks, whereas when it was first approved, it said only 7 weeks of pregnancy. It reduced the number of in-person visits. Initially, the labeling said you had to make actually 3 different visits in person to your clinic to use this medication. After 2016, it was only 1, but of course state law could vary that. And in 2016, it was expanded to allow non-physicians to provide the medication. And then it was also in 2020, and then in 2020, 2021, basically the FDA took steps in 2021 to not require the medication to be provided in person, so dispensed in person, so that it could be provided by mail, for example, like some other medications. So those are kind of the big changes in the availability of the drug that are kind of at issue in this case. But do you want to talk about a general?
As Professor Hill already mentioned, this medication is how the lion's share of abortions are performed in the United States. With the overturning of Roe versus Wade and Casey in the Dobbs decision, it was certainly understandable and anticipatable that anti-abortion organizations would seek to revisit or target the approval of medications that are used to terminate a pregnancy. Subgroups have always claimed that they believe the original 2000 approval was somewhat influenced by politics because of, in particular, the use of this subpart H mechanism, and had long claimed that some of the things that the FDA looked at or the way the FDA evaluated the information was did not adequately consider some of the potential negative effects. But as I think most folks that work in drug policy realize, every medication that gets approved has negative effects. That's not the question that the FDA faces when it approves a drug. The question is usually something of a cost-benefit analysis. And the Tylenol comparison needs a better comparison, because Tylenol is actually not that safe a drug. It probably would not be approved today if it were being submitted for the first time as an over-the-counter medication. That said, many of us use it. Just pay attention to the maximum dose recommendations on a Tylenol bottle. It's actually one of those things that if you don't, it actually can have significant impacts. But for groups that are against abortion, they've always wanted to go after this approval, and obviously the overturning of Dobbs made that available. So in 2022, a group called the Alliance for Hippocratic Medicine filed suit challenging pretty much all of these steps that Professor Hill had mentioned that the FDA had taken, both to initially approve mifepristone and then the subsequent loosening. So they challenged the 2000 approval, the 2016 modifications to the rules, what are referred to as REMS, the 2019 approval of a generic, and then the 2021 decision that was then later formalized in 2023 to essentially not enforce some of the other restrictions. And this is an aggressive legal strategy, in part because in administrative law, we generally expect you to challenge agency actions within some reasonable period after the agency taking that decision. We generally don't like the idea that you can challenge an agency action 2 decades after it was taken, and that was certainly one of the issues they made. So the issues in the case, or that were brought, one is initial, which we're probably going to talk about a bunch, is standing. Is how do a bunch of doctors who aren't themselves taking the medication claim that they satisfy the Article 3 requirements of standing, which for those of you that haven't taken constitutional law yet, you need to be able to assert an injury, in fact, that is fairly traceable to the governmental action you were challenging, and that is redressable if you win. So you need something more than warm fuzzies when of the court saying you were right. You need actually, your injury has to have been redressed in some way. Second bunch of issues relate to timing. How do you reach this 2000 decision to approve the drug as opposed to merely the loosenings of the restrictions on it in 2016 and 2021. There are a bunch of arguments that were raised that relate to something called the reopening doctrine, the idea being sometimes when an agency revises the decision, it is effectively reopening the prior decision. So a bunch of questions about that. Then arbitrary and capricious issues. So AHM's essential claim is that the way the FDA evaluated evidence in 2000, 2016, 2019, 2021, all were improper under the standards of administrative law, in that they did not adequately look at the evidence at issue primarily under a case called State Farm, which I'm assuming is still covered in leg reg. If not, it's definitely covered in administrative law. But if it's in leg reg, it's at the very end of the semester. And then there's the question of what the remedy would be. This suit prompts a countersuit by a bunch of blue state attorneys general. That is kind of weird because they were challenging a decision that actually loosened restrictions, but the idea there was to create a circuit split. District court rules for the plaintiffs on just about everything. A district court in Texas, not the most compelling administrative law decision. I will confess my bias. I generally think that administrative law decisions are often best when done by the DC Circuit, when they're done by a district court judge in some random part of the country, effectively selected by the plaintiffs based on where they decided to file suit. It's a bit of a roll of the dice about how well the administrative law issues are handled. I think that's fair to say that happened here. The Fifth Circuit partially stays that judgment. The Fifth Circuit recognizes that the arguments to try and reach the 2000 decision just don't work. I mean, they're incredibly aggressive. If we want to talk about the details of the reopening doctrine, we can. But basically, the Fifth Circuit doesn't buy that, but buys most of the rest. The Justice Department and Danco, the manufacturer, go to Supreme Court. The Supreme Court stays the entire ruling, goes back to the Fifth Circuit. Fifth Circuit issues a ruling on the merits. Fifth Circuit says no standing to approve the generic approval because if the drug's on the market, the drug's on the market. But finds that there was standing to challenge the 2016 loosening of restrictions and the 2021 loosening of restrictions, and concludes that those were arbitrary and capricious. Essentially arguing that in the Fifth Circuit's view, the agency had not adequately accounted for the cumulative effects of all of the changes the FDA was making to the prescription regime at one time. So that's a brief background of the issues, and I think we were going to start off talking a bit about standing. So.
Sure, yeah, so, and just to be clear, so the Fifth Circuit would roll back the approval of the medication to the terms under which it was available before 2016, which we can talk about the impact of that a little bit at the end if we have time or Q&A, but to be clear that none of these rulings are currently in effect because the U.S. Supreme Court stayed the rulings pending basically its grant of certain, decision whether to grant certain, and its decision ultimately in the case. So nothing has actually changed and won't change unless and until the Supreme Court does something. But yeah, I think personally that this case is likely to revolve around the standing issue, and maybe we can make our predictions if we want. So as Professor Adler said, to show that you are a proper plaintiff to bring a lawsuit, you have to prove that you have been injured in some way by the action that the government has taken that you're complaining about, and that the court, if it gives you relief, if it gives the relief you're asking for, will remedy that harm. And so the group who is challenging the approval of mifepristone is a group of anti-abortion physicians that are basically individual physicians and an organization that they have formed called the Alliance for Hippocratic Medicine. They have alleged that they are, at least some of them, emergency room physicians and OB-GYNs, and that they kind of had like two related theories of harm, of how they were harmed by the FDA approving this medication. One seemed to be that they were just saying that they have in the past treated and are likely in the future to treat complications from this medication, and their whole complaint is that it is unsafe, and therefore that is an injury because it forces them to spend time dealing with these complications, not treating other patients, treating these patients. And then the sort of related theory that's glommed onto that one is that, and because they are opposed to abortion, that they are being forced to violate their consciences when they treat these patients, specifically if in some cases they are treating them for incomplete abortions that they then have to complete, for example. So it violates their religious and conscientious beliefs to have to do this. So the first theory just by itself, that treating complications is an injury, doesn't make a lot of sense from a standing perspective and has basically been abandoned by the plaintiffs because, I mean, again, as Professor Adler just noted, every medication has complications. As a matter of fact, every government action could have public health consequences. And if your job is to treat people who are, coming into the ER, then how can you complain that you're being forced to treat people who come into the ER? That's the job you chose to do, right? So it's far too broad and amorphous a theory of standing. If you add in the conscience theory, it makes more sense as an injury. It's a more recognizable injury, but it's much harder to prove that this, first of all, that this is actually happening and will happen in the future because they're seeking injunctive relief. So they have to show that there's a future harm that they need to be protected against too. Because first of all, there are legal protections for people who do not wish to perform abortions or participate in abortions because of conscientious or religious beliefs. So they'd have to show that those were not going to protect them. And they would also have to prove that the specific changes that are now in front of the Supreme Court in 2016 and 2021 were the cause of these injuries, right? Were the cause of these complications, which is almost impossible to prove. And because Professor Adler is surely too modest to say it himself, I will point out that he was the first person to put this theory out in print, actually, and the government credited him with it. The theory, not the standing theory, but the critique of the standing theory, that they cannot show that the causation is tied to the changes that the FDA made. So, I mean, I think, and then there was a really interesting, and it got a lot of attention, concurrence in the Fifth Circuit by Judge Ho, who had a theory that the plaintiffs were injured because of their aesthetic interest in the embryos existing in other people's bodies, and that they like to treat these embryos, which they view as their own patients, and that they were harmed by mifepristone, which I think that's enough said about the theory. So I think, one question is really how seriously the Supreme Court is going to take standing doctrine in this case, because it has, the conservative majority on the court has a fairly constrained understanding of standing and injury for these purposes, and will the court continue to apply that doctrine as it has in the past and find, if it does, I think there's no way it can find the plaintiffs have standing in this case. And again, my own suspicion is that the court actually will follow its own doctrine in this case, but I'll turn over to you if I got something wrong.
I agree with that. Now, a couple things. I mean, one is the court right now is trying to narrow standing doctrine generally, but is not in a complete agreement about how to do that. So for those that are interested in this, there are cases like TransUnion that are 5-4, where you see, the conservative justices splitting on how to approach standing, or cases like California versus Texas, where I would argue the standing issue was relatively easy, but some of the conservative justices dissenting because they feel that the doctrine has not been applied uniformly. And so this case would be a good case to restrict standing, in part because conservative justices could show that standing doctrine does not necessarily have to have a substantive ideological valence to it. Some complications that I think make it hard, or illustrate part of why standing is hard. I mean, throughout standing law, we recognize all the time that subjective, aesthetically based interests, whether they're based and values-based interests, can be the basis for standing. So environmental citizen suit standing is often based on that. I regularly frequent a particular place. It is meaningful to me spiritually, aesthetically, in some other way. That place is going to be irrevocably destroyed by some governmental action. As long as I can show I regularly frequent that place, I can sue. It doesn't cost me money. It doesn't affect me physically. So I think that the plaintiffs in this case are cleverly building on that those cases and pushing them very aggressively. And Judge O does so even more in his separate opinion below. Whether he's doing that because he believes it or because he's like, hey, these are the rules, have at it, I don't know. But I think it's fair to say. I think that the strongest basis for the court to say there is no standing is that all that is being challenged are the 2016 and 2021 easing of the restrictions on mifepristone. So what the plaintiffs have to show is not that the availability of mifepristone results in X number of complications every year, which will result in X number of emergency room visits, which we think is somewhat likely to mean that some member of this organization will treat somebody, which was their initial argument, and the argument that this circuit accepts. What they have to show is that the marginal change in the number of emergency room visits and complications caused by the 2016 and 2021 loosening of the restrictions is causing an increased number of emergency room visits that affects them. And that's impossible to show. In fact, it's not even clear they could show that about the 2000 approval. I mean, just some numbers that I ran several months ago. So it's an estimated that between 2000 and 2022, 5 million women took mifepristone. If you assume AHM's characterization of the data, which I think Professor Hill might contest, I have no idea if it's right or not, but just using their numbers, that there were between 100 and 350,000 cases in which the women taking the drug needed additional treatment. But that's over a 20-year period. So for any given year, you got to divide that by 20, and so that's 5,000 to 17,000 cases a year. And assume that all of these cases require a visit to an emergency room. We know that's not true, but assume that too. It's far from a statistical certainty that one of those 5,000 to 17,000 cases will, by chance, end up in one of the emergency rooms where some of the hundreds, and it's only hundreds, of AHM members who purport to work in emergency rooms were, especially when you realize that there are over 130 million emergency room visits per year. Right? And that's looking at the 2000 approval, right? And so the additional complications from the 2016, 2021 actions are slicing that so much narrower. And we know from cases like Clapper, which some of you would have read in constitutional law, this was a challenge to the National Security Agency's increased terrorist surveillance, it's not enough to say, well, I think it's likely. It's not enough to say, you have to show that it's relatively certain that you will be affected to satisfy the actual or imminent prong of standing. And the only instance in which a substantial risk is sufficient is if that substantial risk prompts you to engage in costly actions to avoid that risk, which there's no claim of here, right? There's no claim that these doctors are leaving their jobs and going somewhere else to work, make less money to avoid having to be involved in these cases. So under existing law, and the other cases, the case of Summers versus Earth Island Institute, similar sort of thing. Environmental group says, we have all these members, and surely some of them go to the forest that's about to be cut down. And the court's like, well, surely it's not good enough. You need to be able to show that a particular member is going to be is likely to be in a particular location. You can't just try and place a visit. So I think that's the easiest way to find no standing and make the whole case go away. Not hearing oral argument, I would like to think that's what the court will do.
And if I could just jump on, you're going to talk about the administrative law specific issues in a moment, but I just wanted to add too that, mind you, there's actually no showing at all that the 2016 and 2021 changes did have any impact in increasing complications. I mean, plaintiffs have put no evidence in to that effect, that it's statistically or otherwise. So there's that problem in addition to just even if, it would be a problem even if they could, but they can't, or they haven't shown that. And then also, we will talk about this, I think, later if we can, but there's a little bit of a wrinkle in the standing point, which is that some states also intervened in the case below and are trying to intervene at the Supreme Court level. Presumably, it seems to sort of try to cure the standing problems that are pretty evident in the case. But
they shouldn't have standing either, but we can get to that. So the administrative law issues, the primary issue, and there are a bunch. Again, I think in Legray, but certainly in administrative law, you read this case, Motor Vehicle Manufacturers Association versus State Farm, which is actually a case not against State Farm nor against the Motor Vehicle Manufacturers Association, but in fact a suit against the Department of Transportation over changes it made to safety equipment on automobiles. The basic rule is that the agency has to look at all of the important aspects of the problem and show that it considered the relevant evidence. And it's interesting that that's the dominant case because under the plaintiff's theory in this case, the State Farm is wrong, or the government action in that case is more wrong than the court said. What they've essentially argued is because there were no studies purporting to look at what the world would look like with the 2016 and 2021 changes, because the changes hadn't been made yet, it therefore was arbitrary and capricious for the agency to approve the changes because it wasn't looking at evidence of what those changes would produce. And if that were the standard in any sort of context, it would make it really hard for governments to change policies and certainly to loosen regulatory restrictions of any sort because you can't study the absence of regulatory restrictions if the status quo has those restrictions in place. The real issue is the government, typically the standard we typically apply, is the government aware of what its data does and does not show, and does it address it in a convincing or compelling way. Now, I'm not an expert enough on mifepristone to know whether or not when you dig into details, the government's assessments were compelling in that regard, but the primary theory that plaintiffs have put forward and the Fifth Circuit adopted is just clearly wrong, because they're holding the government to a standard that we don't hold regulatory agencies to. There's another wrinkle, which the Danko brief makes as well, which is because this came up on a preliminary injunction, the district court and the Fifth Circuit didn't have the full record. So what they had was the portions of the record relating to the FDA's decisions in 2016 and 2021 that the plaintiffs had wanted to submit as part of their request for a preliminary injunction, not in fact the entire record. So there's another administrative law question, again, if the court reaches it, if it finds a standing, about whether or not it's even proper for the lower courts to have done what they did, because judicial review has to occur on the full administrative record, and that did not occur. And one of the reasons I mention that is if the majority assumes there is standing, this is a really easy off-ramp. right? Which is to say, we don't have to get into deciding whose take on this data is right and whose analysis is right. And we can just say, lower courts, you didn't look at the full record, and send it back and punt and hope the case goes away. But that is another significant administrative law issue in the case. And those are the two that I think are the most important ones. You know, what sort of evidence does the government need to have when it makes a regulatory change? What sort of record does the lower court have to have when the lower court's reviewing an administrative action?
Yeah, and I mean, again, I think, you know, related to that, so yeah, I don't have much to add, but related to that, I think, is the problem that there's no, the plaintiffs haven't shown that the right answer here is that the medication has to be pulled off the market or that the changes have to be rolled back. I mean, if the government didn't sufficiently consider and justify, presumably then the government should just go back and consider and justify, right?
And there's a wrinkle there too, which we don't have a lot of cases where someone other than the manufacturer is suing the FDA over a drug approval decision. There are very, very few. And I mean, the most recent case where standing was found, where nonprofit associations were allowed to sue the FDA for failing to regulate more aggressively, is in litigation that the American Academy of Pediatrics filed against the FDA over vaping regulation, saying you're not being aggressive enough in forcing vaping products off the market. And there aren't a lot of other cases, and I'm not sure that we're standing in that case either, but lower courts disagree. But in any event, the point is, this is an area where we're not used to having someone say, I didn't use the drug, I'm not using the drug, I can't claim to be harmed by the drug, but I don't like the fact that other people are using the drug, I'm going to challenge the FDA for that. We just don't have a lot of case law. I mean, there are a handful, but not really looking at that posture, which complicates it.
Yeah, and actually the government asserts in its brief, and this is a quote, to the government's knowledge, this case marks the first time any court has restricted access to an FDA-approved drug by second-guessing the FDA's expert judgment about the conditions required to assure that drug's safe use. It's a very carefully crafted sentence, I think, but you know, it emphasizes the sort of really unusual nature of this case. I'll also note that some of the studies that the plaintiffs apparently relied on below that were published in medical journals were recently retracted by that journal after they discovered conflicts of interest and flaws with the methodology of the authors of those studies. So it's, yeah.
Here's we'll get a little bit far. So this is something I've said publicly. That line from the government's brief, and if you listen to the oral argument in the circuit, it's how the argument opens. Really the wrong way for the government to argue this case, right? The argument can't be the FDA is some super special agency that we can't question, because that is never the way we approach expert agencies in administrative law. Never. We subject administrative agencies' actions to judicial review precisely because we recognize agencies like anybody else can make mistakes, and even experts can make mistakes, and on top of that, that agency decisions are not mechanical scientific judgments, they are value-based judgments. How do we evaluate risk A versus risk B and trade those off? There's no mathematical formula for that. And we expect the agencies to engage in reasoned decision-making and to explain it. So if, in fact, the FDA, like FERC or the EPA or OSHA or any other regulatory agency, did not engage in reasoned decision-making, and that can be shown, it would be perfectly appropriate for a court to set that aside. That happens every week, but every month in the DC Circuit, some expert agency's decision is set aside because it was arbitrary and capricious or otherwise violated administrative law standards. And I do not understand why the Department of Justice attorneys, some of whom I know and some of whom are incredibly good attorneys, are insisting on trying to make this a referendum on the FDA rather than a more straightforward application of administrative law principles. I think that, because I think what it walks right into is, if one is inclined to believe that the initial 2000 approval was at all politically influenced, then you're essentially saying that agencies that may be subject to political influence get a free pass, and that can't be right. And in this, in the Fifth Circuit, when this case was argued, the opening of the oral argument by the Solicitor General's, not Solicitor General herself, but one of the Deputy Solicitor Generals who was arguing the case, is all about, first time, second guessing FDA. The day before, the Fifth Circuit had heard an en banc case involving FDA regulation of vaping products, in which it was pretty clear the FDA played fast and loose with its own approval standards in denying approval. And 2-3 weeks ago, the FDA issued that decision, the Fifth Circuit issued that decision, just lambasting the FDA. The FDA is not infallible. We have judicial review because even expert agencies can make mistakes. The issue should not be FDA, oh, you never make anything, you never make the wrong decision. It should be, you have to be someone that satisfies Article 3, and you have to show that the FDA didn't do what we expect agencies to do, which is to look at the issues, explain why they make the decision, explain why they made it, and that's typically all that we require, right? The FDA can say, well, this is why we think loosening these restrictions will reduce complications, will increase access to reproductive health, and improve various health outcomes, and here's why we think that outweighs whatever risks there are of that. And agency does that. You don't say, oh, agency's perfect. You say, oh, the agency gave us a reasoned decision that they explained, and we uphold that. Right? It's a very differential standard, but it's not this, first time agency ever overturned.
So look, I don't disagree that the FDA makes mistakes, and case in point, the shoe might very well be on the other foot if a conservative administration, right, tries to revoke the FDA approval of mifepristone in the future, like a year from now. But I also don't think that was the government's point, and I do think if decisions can be second guessed based on the unbelievably flimsy and they were pulling studies off of online websites where anonymous people posted their experiences with the medication. I mean, if it can be second guessed based on this, this, in other words, to flip it around, this is not the poster child case either for the FDA can make mistakes and the courts
I agree with that. I think
are an important safeguard.
I agree with that. Generally, I remember working on cases like this, all sorts of cases. Why did the agency put more trust in study A than study B? Well, we expect the agency to say, well, we found study A to be more reliable because it was published in a peer-reviewed journal and it involved a large number of test subjects or whatever, and study B was, online survey. We generally say, the court doesn't have to be convinced that the agency judgment was right, and that's a good rule, I think, right, because the judges aren't experts. The court just needs to say that the FDA gave that explanation. So the FDA's claim is, which again is probably correct, that if you looked at the full record, which none of the lower courts did, you would find that the various concerns you might have about how do you model loosening 5 restrictions simultaneously when you can't study that, I would be surprised if the FDA hadn't thought of that and hadn't discussed that in their approval, in which case there'd be no basis for second guessing it. But again, anyway,
okay.
We're going to talk Comstock?
I want to take the last few minutes for us to talk about Comstock a little bit because although it's maybe not the most central issue in the case, I think it's one of the more interesting ones and it's one that's likely to come back. So as some of you may know, there's something called the Comstock Act that was passed in 1873 that I will remind you some U.S. history was before women had the vote in this country, that says, and the current text of it reads essentially, I'll read the operative part. Every article or thing designed, adapted, or intended for producing abortion is declared to be non-mailable matter and shall not be conveyed in the mails or delivered from any post office. And then there's another provision that applies to private carriers and common carriers, like UPS and whatever. The question is, so this was a law that was passed in 1873, has not been enforced in many, many decades, at least in part because of Roe v. Wade being the law of the land. It was not understood to be enforceable. There's an argument being made in some circles now that the Comstock Act has never been repealed. It's on the books. It has applicability, including here in this case. And again, our friend Judge Ho in the Fifth Circuit argued that it was another basis for finding that the FDA's approval of mifepristone, and particularly, not the approval, I guess the loosening of the 2021 restriction, the loosening in 2021 of the restriction on mailing mifepristone was not legal and was, arbitrary and capricious, essentially. So I think we definitely disagree, I think, on whether or not this law can currently be enforced. It has, as I noted, has not been enforced for a very long time. There were several circuit court opinions in the early part of the 20th century interpreting Comstock, which is a federal law, so federal courts interpreting federal law, to mean it only forbids mailing of such instruments into places where, for use in illegal abortions, I should say, so in contravention of the law. So only if you knew that it was going to be used in a crime, basically. And just to, one reason why I think that Comstock can't be enforced and certainly can't be intended as broadly as its language suggests is that, this would have effects far beyond mailing of mifepristone to mean that, like, you couldn't mail anything that could be used even in a life-saving abortion. So, manufacturers cannot ship forceps, they cannot ship mifepristone, but they cannot ship either misoprostol, which is the other medication that's used in the medication abortion, which is also has numerous other medical indications, including it's an ulcer medicine, but it's also used in inducing labor. So in any case, it would have, if it were enforced as written, would have extraordinarily broad implications that, again, cannot possibly be intended by Congress.
So a couple comments. So first, there's a New York Times article that was that yesterday, day before, about this, that very prominently quotes Jonathan Mitchell, who was the author of Texas SB 8, which was the Texas kind of bounty on abortions law. If you're interested in this issue, you should read the article. The Mitchell quotes are they're very Jonathan Mitchell, is I guess the only way to put it. So this is interesting. So on the one hand, I think we agree that the Comstock Act, even though AHM is trying to put it into the case, and the states that are trying to intervene are trying to put it in the case, is actually not in the case. Because for it to be in the case, you would have to argue that in 2000, 2016, or 2021, the FDA's decision to make to approve or loosen the restrictions on mifepristone was arbitrary and capricious because it failed to account for Comstock. And that can't be right because Comstock certainly in 2016, 2021 was unenforceable because it would be an undue burden under Casey to limit the availability of medication abortions because it would effectively outlaw them in any state other than where they're manufactured. So that it wasn't arbitrary and capricious. So Comstock's not a part of this act. The other reason it's not a part of this, and this is just kind of a basic administrative law point, is that the FDA is not the agency that enforces the Comstock Act. And in general, we don't say to government agencies that issue permits or issue regulations, you have to make sure when you're issuing a permit or giving approval that every other approval that this private entity would need to operate has also already been given. No, you need to get your FERC approval from FERC, you need to get your EPA approval from EPA, and your Army Corps of Engineers. So the FDA approving of mifepristone doesn't immunize manufacturers against a Comstock prosecution by the Department of Justice, nor is the FDA required to consider it. Right? The question is whether under FDA's rules, it is a violation of FDA's rules to distribute mifepristone. And so I don't think that would be an issue. Could there be a petition to FDA to reconsider Comstock in light of Dobbs being overturned? Maybe, but that hasn't been done. Where I think we disagree is that I think as written, under existing jurisprudence, right, so Dobbs, restrictions on abortion are subject to the rational basis test. Under cases like Gonzalez versus Raich, where, and to go back a bit in constitutional law, Champion versus Ames, where the Supreme Court said, you want to ban something purely for moral purposes in interstate commerce, no problem. Yeah, and the law has a knowing requirement. There is a mens rea requirement, so I don't think it reaches things like forceps. It might not reach even other medications, and the question would be, could you reach mifepristone insofar as mifepristone is also being distributed for other purposes? But you could certainly, an administration that is inclined to, and the New York Times story from this weekend talks about what a future Republican administration might try and do with this law. It's on the books. I think could enforce it against the manufacturer, could enforce it against distributors who are distributing mifepristone for the purpose of terminating pregnancies and knowing that they are doing so for that purpose. And there's also language in the Comstock Act that talks about the distribution of the materials that describe how to use it for that purpose. Now, some of you might be saying, wait, that's a huge First Amendment problem. I kind of agree, but the courts don't. Drug and device regulation is largely predicated on the FDA placing restrictions on what manufacturers can and can't say about their products. And to market a drug illegally is typically defined as to describe its use or promote its use for a purpose other than the approved use, which is why FDA drug approval is so focused on the language of the label. So it may be the case that drug and device regulation more broadly raises a lot of serious First Amendment questions that the courts have never fully confronted, and those First Amendment questions would also apply to Comstock. I'd agree with that. The problem is the courts have shown no interest in that, and there's no reason why, if I'm a drug company and I'm not allowed to tell anyone other than doctors about the potential off-label uses of my drug, and that's okay under the First Amendment, it's not clear why you can't say to Danco, you can't tell people that mifepristone can be used to terminate pregnancies without selling it as a misbranded medication. So I think Comstock could be enforced, it's a problem sometimes of leaving really old laws on the books and not repealing them, because Comstock's been sitting around for 150 years.
Yes. Okay, so I think rather than respond, I think I'll open it up for Q&A so that we can hear from folks. Oh,
Let me just give the CLE.
oh, okay.
So, Shelby, any online? No. Okay, so for those online, the CLE code, or anyone here, the CLE code is 542272. 542272. And do you want to call on people? You want me to?
Sure. Right here, the second row.
So do you think that some more recent cases that the court has ruled on where the plaintiff may have had dubious standing, I'm thinking maybe 303 Creative, could make it easier for this case to have standing?
I would reject both the premise and say no. So I think standing in 303 Creative was easy because we have looser standards in the First Amendment cases. We accept showing in the First Amendment in the way we do in other contexts, and the state conceded everything that would have allowed contesting standing there. That said, I do think that when you look at the Alito dissent in California versus Texas, when you look at the way the court was willing to embrace a somewhat bespoke standing analysis in the student loan case, which is defensible, but kind of it seems at odds with, say, the cases like TransUnion, and there's another one, and their failure to be more aggressive in the immigration case from last year, where Texas was challenging lack of immigration enforcement, certainly leaves it open, and standing doctrine historically has not been the most consistent thing in the world. So I would think if the court's serious about trying to make standing consistent, they kind of have to be very skeptical here. Are they serious about that?
Yeah, I mean, it's not because I put it past the court to be somewhat results-oriented in this case that I say that I still think this case is going to go off on standing grounds, because I just think, I mean, first of all, this sets such a problematic precedent, I think, for future challenges, even to, FDA actions, but also because the merits are so messy and such a, it would just create such chaos that I really think that the court just doesn't want to go there, and it's very clean and justifiable to decide on standing grounds, so that's why I suspect that this is not going to be another one of those cases, unlike, where the court might have been more eager to reach the merits in certain other cases.
Do you think that there's any, merit to the fact that this might become a slippery slope where a anti-COVID vaccination doctor might refuse to treat a patient that has a COVID vaccination, or a Catholic doctor might refuse to help a patient with birth control issues or something like that?
Yeah, I mean, I don't think that the issues of refusal to serve or to treat are directly posed here, but could those folks then use that as a basis for challenging the FDA's approval of birth control, or the FDA's, approval of a vaccine to treat COVID or something? I mean, I think that seems more plausible if the plaintiff's theory of standing is accepted here.
And those suits, there are some suits like that were filed, and that courts generally consistently said no standing. Things like about approval of vaccines, and So I assume the court's going to be aware that it's hard to create standing to challenge this approval without creating standing to challenge a lot of other things. On the conscience issue, there's two little things. One is in the lower court, one of the arguments the federal government made against standing here was saying, well, in most jurisdictions, the doctor can exercise their conscience right so long as it doesn't deny the patient with the care they're entitled to. So the idea being that so long as you're not the only doctor that can perform the procedure, you can opt out. And we see that sort of thing in the Hobby Lobby case with regard to including contraceptives in Japan. What the plaintiffs responded with is whether or not the federal government's interpretation of EMTALA is consistent with that. And it so happens there is another case on the court docket this term, which you should have another form about, involving how the extent to which states that restrict abortion are obligated to allow abortion through forms, for example, in the context of Medicaid, in emergency situations, and in particular, who defines what an emergency is. So that's, the court's actually going to address that pretty directly in what I think is going to be the last case they hear this term. And maybe Professor Hoffman will organize a panel on that, because that's a really important issue and question as well. In that particular case, a lot of it focuses on the statutory language. But
I always like to come out with more work from these forums. So what is your prediction as to the outcome of this case, each of you?
I mean, I think the court is going to find that there's no standing and dismiss it, and yeah.
7-2 or 6-3 no standing, if I had to predict. Another thing that hasn't come up, reason why there's no citizen supervision, right? There's no express statutory authorization of litigation here. The plaintiff's argument for associational standing also relies very heavily on a case called Havens Realty, which the court has shown an interest in getting rid of. There's a case, Atchison Hotels, which the court decided on mootness grounds this past fall, that was tailor-made to get rid of this. The idea being that anytime the government does something that makes more work for a mission-oriented nonprofit, the mission-oriented nonprofit is injured and therefore can sue. It's a crazy rule, and it seems court to get rid of it, and this is a case where they could get rid of that too. So I think 6-3, no standing if I had to predict.
So for cases like Bryant v. Stein, or I know there's Gen Bio Pro Inc., where they're attacking the states directly and like they're more narrow restrictions than the FDA approval. Like, if you think those cases will proceed, like, how do you think that those will turn out based on like the federal-state balance?
So are you talking about the cases where they're arguing that like the state bans are preempted by the government's approval of mifepristone? Yeah, that's an interesting. So there are these cases, and the big one is proceeding in West Virginia, where, or the main one, I guess I should say, or I think it might be the only one now, where the state totally bans abortion, and the manufacturer of the generic mifepristone is saying the FDA approving mifepristone preempts that state law because, I mean, in the theory is sort of that federal approval of a medication is like a license to sell it, right? And so the government's sort of federal license should overcome any state attempts to restrict it. I think and I'm glad you raised it, I think it's a hard argument. I think it's a hard argument to overcome an actual ban because they're not, I mean, there is language that I think in the West Virginia law that specifically targets medication and abortions, but it's really it's just a ban on, terminating pregnancies. It's not like a ban on mifepristone. And I think that even if it were, it's not clear that it would be preempted. But I think it's much harder because of that. I think if there are specific restrictions, however, that go beyond the federal license or the federal restrictions, I think there's a better argument in that case, although I'm still not certain that those are preempted either.
Yeah, I think the preemption arguments are really hard. So I mean, it's interesting. The issue of whether the FDA can preempt state law has been around for a long time. It rose up pretty significantly in the early 2000s when the Bush administration wanted to preempt various state restrictions on drugs, various labeling requirements, which were imposed through tort law. The general reaction of the courts and most commentators was the FDA can't do this administratively. If Congress wants to preempt, Congress can, but an agency does not have any authority to do that administratively. I think that was the correct judgment, so I think the same thing would apply here. If anything, it's a hard argument to make now for two reasons. One, you have a bunch of conservative justices. Historically, in the late 20th century, most conservative justices were somewhat pro-preemption. It was kind of seen as a pro-business thing. Several of the conservatives on the court now are quite anti-preemption. So if you look at a case like Virginia Uranium, Justice Gorsuch, Justice Thomas, Justice Kavanaugh, very skeptical of preemption and finding preemption anywhere that Congress hasn't expressly authorized it. Number one. Number two, it's pretty clear with the major questions doctrine that an agency power to preempt would be a major question. And so even if we weren't already skeptical of an ability of an agency to do that administratively, under existing doctrine, I just don't see how that goes anywhere. The more interesting question would be, what if Congress amended the Food, Drug, and Cosmetic Act to say states can't limit approved drugs, and you get that passed, that would probably hold up. But I think in the current posture, really tough.
And just one gloss on that, like the FDA approves like sale and marketing of medications, not uses. And it gets a little messy, especially with a drug like this, where it did regulate like how it's prescribed because it added additional restrictions. But like the West Virginia law is a, if anything, it affects use and not marketing and sales. So that's not primarily anyway. So yeah, it's another.
So I think we're going to have to end it here so that we can get to civil procedure class and other classes. And so thank you so much. This was a fabulous program.